The use of force, in the context of law enforcement, may be defined as the amount of effort required by police to compel compliance by an unwilling subject. Use of force doctrines can be employed by law enforcement officers and military personnel on guard duty. The aim of such doctrines is to balance the needs of security with ethical concerns for the rights and well-being of intruders as suspects. Injuries to civilians tend to focus attention on self-defense as a justification and, in the event of death, the notion of justifiable homicide. U.S. military personnel on guard duty are given a use of force briefing by the sergeant of the guard before being assigned to the post. For the English law on the use of force in crime prevention, see self-defense in English law. The Australian position on the use of troops for civil policing is set out by Michael Hood in Calling Out the Troops, Disturbing Trends and Unanswered Questions. Compare use of deadly force by the South African Police Services revisited by Malibo Kebine C. Banda and Omthimetse C. Banda. History. Use of force dates back to the beginning of established law enforcement, with a fear that officers would abuse the power. In today's society, this fear still exists, and one of the ways to fix this problem is to require police to wear body cameras and to have them turn on during all interactions with civilians. Use of force continuum. The use of force may be standardized by use of force continuum, which presents guidelines as to the degree of force appropriate in a given situation. One source identifies 5 very generalized steps, increasing from least use of force to greatest. It is only one side of the model, as it does not give the levels of subject resistance that merit the corresponding increases in force. Each successive level of force is meant to describe an escalating series of actions an officer may take to resolve a situation, and the level of force used rises only when a lower level of force would be ineffective in dealing with the situation. Typically, any style of a use of force continuum will start with officer presence, and end with the use of deadly force. Presence, verbalization, empty hand control, intermediate weapons, deadly force. Use of force continuums can be further broken down. U.S. case law. Graham v. Connor. On November 12, 1984, Graham, who was a diabetic, felt an insulin reaction coming on and rushed to the store with a friend to get some orange juice. When the store was too crowded, he and his friend proceeded to go to another friend's house. In the midst of all this, he was being watched by Officer Connor of the Charlotte City Police Department. While on the way to the friend's house, the officer stopped the two of them and called for backup. After several other officers arrived, one of them handcuffed Graham. Eventually, when Connor learned that nothing had happened in the convenience store, the officers drove Graham home and released him. Over the course of the encounter, Graham sustained a broken foot, cuts on his wrists, a bruised forehead and an injured shoulder. The Supreme Court held that it was irrelevant whether Connor acted in good faith, because the use of force must be judged based on its objective reasonableness. Tennessee v. Garner. On October 3, 1985, officers Elton Hyman and Leslie Wright of the Memphis Police Department were called to respond to a possible burglary. When they arrived to the scene, a woman standing on the porch began to tell them that she heard glass breaking and that she believed the house next door was being broken into. Officer Hyman went to check, where he saw Edward Garner, who was fleeing the scene. As Garner was climbing over the gate, Hyman called out, "Police, halt," and when Garner failed to do so, Hyman fatally shot Garner in the back of the head, despite being reasonably sure that Garner was unarmed. The Supreme Court held deadly force may be used to prevent the escape of a fleeing felon only if the officer has probable cause to believe that the suspect poses a serious risk to the officer or to others. Nelson v. City of Davis. On April 16, 2004, what was supposed to be known as the biggest party in history took place at the annual UC Davis picnic. Due to the large amount of participants at this party, people began to illegally park their cars. Sergeant John Wilson demanded that officers start to issue parking tickets to the illegally parked cars. Tickets were also issued to the underage drinkers. Wilson called the owner of the apartment complex because of the disturbances that were being caused, loud music and the sounds of bottles breaking. Wilson was consented by the complex apartment owner to have non-residents to leave the complex. 30 to 40 officers were rounded up with riot gear, including pepperball guns, to try and disperse the crowd of 1,000 attendees. The officers gathered in front of the complex where 15 to 20 students, including Timothy C. Nelson, were attempting to leave, but no instructions police were given by the police. Officers began to fire pepper balls, one of which struck Nelson in the eye. He collapsed immediately and was taken to the hospital much later on, where he suffered multiple injuries, including temporary blindness and a permanent loss of visual acuity. He endured multiple surgeries to try and repair the injury. Nelson lost his athletic scholarship due to his injury and was forced to withdraw from UC Davis. The officers were unable to find any criminal charges against Nelson. The Ninth Circuit held that the use of force was unreasonable and the officers were not entitled to qualified immunity. Plumhoff v. Rickard. On July 18, 2014, a West Memphis police officer stopped Donald Rickard for a broken headlight. As the officer talked with Rickard, he noticed that there was an indentation in the windshield and that Rickard was acting very erratic. The officer asked Rickard to step out of the vehicle. Rickard at that point fled the scene. A high-speed chase ensued, which involved several other officers. Rickard lost control of his vehicle in a parking lot, and officers exited the vehicles to approach Rickard. Rickard again tried to flee, hitting several police cruisers and nearly hitting several officers. At this time officers opened fire on Rickard. The officers fired a total of 15 rounds, which resulted in the death of both Rickard and his passenger. The Supreme Court ruled that the use of force was justified, because the objective reasonableness of the use of deadly force must be based on the situation in which it was used, and not on hindsight. U.S. statistics. Of the 40 million people in the United States who had face-to-face contact with the police, 1.4%, or 574,000, reported use of force or the threat of use of force being directed at them. About a quarter of the 574,000 incidents involved the police officer pointing the gun at the subject of the incident, and 53.5% of the incidents saw the officer using physical force such as kicking, grabbing, and pushing. In addition, 13.7% of those that had force used against them or were threatened with the use of force submitted complaints to the offending officers' department. Of those that received use of force from a police officer or were threatened with use of force, almost 75% reported that they believed it was excessive and unwarranted. This statistic was consistent across the Caucasian, African American, and Hispanic races. Officer attributes. Education. Studies have shown that law enforcement personnel with some college education use force much less often than those with little to no higher education. In events that the educated officers do use force, it is usually what is considered reasonable force. Despite these findings, very little, only 1% of police forces within the United States have education requirements for those looking to join the forces. Some argue that police work deeply requires experience that can only be gained from actually working in the field. experience. It is argued that the skills for performing law enforcement tasks cannot be produced from a classroom setting. These skills tend to be better gained through repeated exposure to law enforcement situations while in the line of work. The results as to whether or not the amount of experience an officer has contributes to the likelihood that they will use force differ among studies. Other characteristics: it has not been strongly found that the race, class, gender, age, etc. of an officer affects the likelihood that they will use force. Situational factors may come into play. Split-second syndrome. Split-second syndrome is an example of how use of force can be situation-based. Well-meaning officers may resort to the use of force too quickly under situations where they must make a rapid decision. Departmental attributes. Policies on use of force can differ between departments. The type of policies established and whether or not they are enforced can affect an officer's likeliness to use force. If policies are established, but not enforced heavily by the department, the policies may not make a difference. For example, the Rodney King case was described as a problem with the departmental supervision not being clear on policies of force. Training offered by the department can be a contributing factor as well, though it has only been a recent addition to include information on when to use force rather than how to use force. One departmental level policy that is currently being studied and called for by many citizens and politicians is the use of body cameras by officers. In one study, body cameras were shown to reduce the use of force by as much as 50%. Crime levels. At the micro level, violent crime levels in the neighborhood increase the likelihood of law enforcement use of force. In contrast, at the meso level, violent neighborhood crime does not have that much effective use of force. Prevention. The police have had trouble with preventing the use of brutal or excessive force. Many cases of force have gone public through the media. These cases have led to an outcry by the public to prevent excessive force through movements Black Lives Matter or Hands Up, Don't Shoot. Quote, to help aid in the prevention of excessive or brutal force can be as simple as increased education, a rise in police accountability, and through experience. It has been shown, officers who have 2 years or more of college education are 30% less likely to shoot a civilian than an officer with less than 2 years of college education. Police-worn body cameras will hold officers accountable, with an accurate, unbiased account of video with police interaction with the public. Experienced officers rely on experience to make appropriate decisions in high-risk, high-stress situations. England and Wales. In England and Wales, the use of force is provided to police and any other person from Section 3 of the Criminal Law Act 1967, which states, a person may use such force as is reasonable in the circumstances in the prevention of crime, or in effecting or assisting in the lawful arrest of offenders or suspected offenders or of persons unlawfully at large. Use of force may be considered lawful if it was, on the basis of the facts as the accused honestly believed them, necessary and reasonable.